Hi, my name is Dana Smith. I'm the director of the Academic Success Program. So this session is going to give you a high-level overview of the skills you'll be developing throughout the first semesters of law school and beyond. My goal in this video is really to give you the information you'll need to be ready to go for your first few weeks of class. But please keep in mind that you're going to continue to refine these skills not only throughout your first semester, but really throughout law school and even into your legal career. So here are all the session goals. It's a lot, but hopefully you'll see how it fits together in the broader process by the end. Throughout the video, there will be opportunities to practice the skills that we're talking about. So practicing case briefing, practicing synthesizing a rule. And so I'll charge through, but I do encourage you to pause the videos as necessary to try out the skills before hearing my answers. And I'll try and remind you to do this throughout, or else take little pauses so you have a chance to hit pause before I just launch into what the answers are. Zooming out here, let's talk broadly about the process of being a lawyer. And so here's that representation, and this is what we're training you to do in law school. And so different skills in this video will relate to different steps in this process, but you'll really work on skills that address this process throughout law school. That's what we're getting you ready for, is to be a lawyer and work through this process on your own. So, walking through, a client approaches you with a problem, you're going to do the work gathering the facts of whatever that problem is. Then you'll turn to researching the law so that you understand the governing rule. Lawyers don't just know every rule of law on earth in their mind. They have to research the law to understand the governing rule, and then to further understand what parts of the rule that are going to be most critical and what do you have to explain. Then you'll return to your client facts and kind of sort through to see which ones are critical. Your client is coming to you because they don't know what the law is or how to analyze it, and so they don't always give you just relevant facts. There's going to be some extraneous stuff, so you have to do some sorting. And then you're going to really think about how you're going to apply the law that you researched and honed in on to those clients' critical facts and put them together to reach a conclusion. And so that's basically the process of being a lawyer. I mean, it happens over and over and over and over again in practice. This is also the process of taking a law school final exam. This is kind of what we're trying to simulate in the exam process. And so throughout, your time in law school, throughout your first semester, you're going to be learning skills that you need to address certain portions of this process. The first one of those skills is case reading and briefing. And this really addresses the researching law and the understanding the governing rule pieces. So a note about reading cases. So you're going to be assigned case law, so case, judicial decisions, as part of your reading in your classes. And you're probably going to find reading cases to be quite difficult at first, but it gets easier over time. The reason cases can be tricky is because they are primary sources of law. Cases are developing law every time there's a case. There's a potential for new law to be developed. So cases are primary sources. And because you're reading judicial decisions, you're reading something that the judge didn't write to teach you. They wrote it to solve the problem in front of them in their courtroom that day. And so because the judge isn't writing to teach you, there is a little bit of digging through the cases to figure out what you need. And case briefing is a way to organize your reading notes and thoughts to use during class. So it's really just a way to figure out what information do I need and what is that information so that you have it at your fingertips while you're, in class having a discussion or taking notes on your case brief, whatever it is. You usually won't be asked to turn in your case briefs, but you should do them still, even though you're not going to turn them in for the most part, because they can be super useful when you get cold called in class to follow the class discussion, and also when you go back in to do some of your outlining and getting ready for exams, the case briefs can be helpful. So a little bit about the parts of a case brief. So if you completed Lawyering Fundamentals, which we offer in conjunction with Barbary, you may have seen different labels for the different parts of a case brief. I like to present a few ways to categorize the information because oftentimes case briefs are going to be styled to your individual preferences. And you may also style your case briefs after how your professor teaches and what they're really interested in discussing in class. For example, some professors really love to dive deep into the facts of a case, while others just want a one-sentence summary of what the relevant facts were. And so once you get a sense of what your professor is looking for, you will tailor your case brief to what you need. So here are how I think about the parts of a case brief. Other sources, lawyering fundamentals, other books may have different categories, but they're all getting you to the same place. So first, the caption, so the name of the case, the court, the year, the parties, who are the individuals or entities involved in the case, what's their role, the procedural history. So how did the case get before the court? So what happened? Oftentimes you're going to be reading appellate court decisions. So what kind of happened to bring it to an appellate court? The facts. So what happened to cause the court case? And really thinking about, can I limit these to the most relevant facts that really triggered the court to make the decision it did? There's also generally going to be one or two in your casebooks, issues or questions presented by the case. When you read full unabridged cases, there are often many issues before the court, but usually your textbooks do a pretty good job of limiting it to just one or two issues presented. So that's really just asking what legal issue is the court addressing. And so if that's the question, the holding's the answer. So what did the court decide as to that question? The rules are the legal rules. What did the court establish or rely on here? The reasoning, why did the court reach the outcome it did? The disposition is what happens next. Will it be remanded back to the trial court for further consideration? Was the trial court affirmed, meaning that the trial court did it correctly? So what outcome and what happens next? And then if there are any dissenting or concurring opinions, you would just summarize those as well. So let's look at what a case looks like and kind of try to categorize information together. And this is an instance where I'm going to go line by line. I'm basically going to read this case to you, but this is an instance where you might want to pause and predict how I'm going to classify different information as we go through. So this is a Georgia Court of Appeals case from 2000, Clark v. Joyner. So already you probably you have your information for your caption. So the name of the case is Clark v. Joyner. It's a 2000 case. It's out of Georgia. You probably have a suspicion that there is someone named Clark and someone named Joyner. So maybe starting to get your parties down. But let's start digging in. So we go to the opinion and we see that presiding judge is Judge Andrews. And we start off, we granted Thomas and Beverly Clark's application for interlocutory review after the trial court denied their motion for summary judgment on John Joyner's claim for damages from a dog bite. A ton to unpack here. The first thing I want to mention is interlocutory review. What the heck is that? So when you find a phrase that you aren't familiar with, pause right there and look it up. It's important to understanding what's happening in this case. So I'll do the looking up for you in this one. An interlocutory review happens in the middle or in the midst of a trial, an actual trial. So some question comes up that's so important that it gets sent up to the Court of Appeals so that then the trial court can use that decision to inform how it proceeds. So we also know from the sentence that we have Thomas and Beverly Clark as parties, so the Clarks together. We know that there's some procedural history here, that the trial court denied a motion for summary judgment, which is just a motion to end the trial early. On John Joyner's claim, so John Joyner's obviously a party, and they are, in this case, the plaintiff, because John Joyner is bringing the claim for damages from a dog bite. So we know that Joyner is going to be the plaintiff. The Clarks then are likely the defendants because they're trying to stop the plaintiff's claim early. And we know it's a dog bite case. So we have a little bit of facts going on. So a lot even to unpack from the first sentence. This is why reading cases takes so long at the beginning. You need to pause and look up phrases like interlocutory review. Maybe you looked up motion for summary judgment. So a lot of information here. Next sentence. Because there is no evidence that the dog had ever bitten anyone before or that the Clarks knew that the dog had any propensity to bite someone, we reverse. So take a moment and think, where does some of this information go? So the first thing that I see, this because indicates to me that this might be some reasoning because there is no evidence that the dog had ever bitten anyone before or that there was knowledge of propensity to bite. So two kind of reasonings here. No evidence that it happened before or the Clarks knew that the dog was going to bite someone. And then we reverse. That's going to be your disposition. So that's what happens next. The appellate court is reversing the trial court's denial of the motion for summary judgment of Joyner's claim. Next sentence. This case arose when Joyner went to the Clarks' house to sell them insurance. This seems like maybe some facts. So Joyner is selling insurance at the Clarks' house, so perhaps on the Clarks' property. Maybe that's important. We're not really sure yet. I'll charge on through the paragraph. Joyner had gotten out of his car and was walking to the house when the Clarks' two dogs ran toward him. Joyner said the dogs did not act hostile, but ran at him as if they wanted to play. When he put his hand out to keep them from jumping on him, one of the dogs, Bud, a mixed breed 12-year-old male, grabbed his hand and bit it. After Joyner got his hand loose, the dog jumped up and bit him in the side. So right away, if you're classifying this information, you're probably thinking that these are facts. These are the facts giving rise to the claim, and you'd be correct. This is a very fact-heavy paragraph. This is often how you'll see the facts in cases. There'll be a summary paragraph of what happened, not always, but often. But when you're thinking about, okay, so I know these are all facts, how do I write these into my brief, which I'll show you my brief for this case after we get through it. But you're really going to be thinking about what is important to the court's decision. So obviously we don't fully know the law here yet. We haven't gotten there, but maybe you're thinking, okay, there's a couple dogs, there's no not acting hostile, Joyner's walking up to the house, so on their property, and then we have one of the dogs' name is Bud. Now it's fun to know that that's the dog's name, but probably not super legally relevant that the dog's name is Bud. So you might just note it for yourself because it's a cute detail, but probably not going to be the most relevant fact for understanding the legal analysis that the court's about to do. The same perhaps with, depending on what the jurisdiction ends up saying, also maybe knowing mixed breed 12-year-old male, maybe not important, maybe important, unclear at this point, but just keeping track of, okay, we have some facts here. We know there's some dogs. Mr. Joyner came to the Clarks' house to sell insurance and is walking up to the house and their dogs run out and Bud bites him. The next part of this case. So OCGA section 51-2-7 provides an pertinent part. Take my word for it, this is a statute. So this is Georgia's statute that's going to be relevant to this case. So I'll give you a moment to read it. Feel free to pause to read through the statute. A lot of detail there. But then after the statute, we get a little bit more detail. And so in order to support an action for damages under this statute, it must be shown that the dog was vicious or dangerous and that the owner knew it. The dog's nature and the owner's knowledge are two separate issues, and proof of both is necessary for recovery. So what are we categorizing this as? These are rules. So you might not need to copy and paste the entire statute into your case brief, but this section is the legal rules that are governing the case, starting with the statute, which is where many laws originate with a state or federal statute. And then the paragraph underneath, starting with in order to, are the rules from cases that have interpreted this statute. And we know that there are two things that we need to think about here, the dog's nature and the owner's knowledge. And you need both. So it's an and statement, not an or statement. So dog's nature and the owner's knowledge. So maybe in your case brief, you write 1, dog's nature, 2, owner's knowledge, both elements of proving, supporting an action for damages under this dog bite statute. So then I did edit this case a bit for purposes of this video so that I wasn't reading to you for like 12 hours. So these 3 asterisks here just mean I took something out. So then diving in, there is also no evidence that the Clarks knew that the dog was vicious or dangerous. So, okay, imagine that this is in your casebook. The casebook editors took out some stuff and started out with knowledge. So remembering that our rule requires evidence that the dog was vicious or dangerous, so the dog's nature, and evidence that the owner knew about it, being 2 separate issues, it sounds like we have jumped now to point 2, the owner's knowledge. And here there's no evidence that the Clarks knew that the dog was vicious or dangerous. So this is a bit of like reasoning, right? Like this is why the court's going to ultimately reverse the denied motion for summary judgment. Because remember, it told us that in the first paragraph. Both of the Clarks testified that Bud had never bitten anyone before, and there's no evidence in the record of a previous bite. So going back a little bit to part 1 of the rule, but this also speaks to knowledge. Joyner claims, however, that the Clarks were on notice because Bud acted aggressively toward an animal control officer who had previously tried to remove a hurt stray dog in heat from underneath the Clarks' porch. Manning, the animal control officer, testified that Bud never growled or barked at her, but just exhibited a very protective, aggressive posture. So what are these? Potentially more facts, right? So some relevant facts here being that there's potentially this instance where Bud was maybe a little bit aggressive. So that's kind of influencing the court's decision. But if we read on, the Clarks were not at home at the time of the incident and therefore were unaware of the problem. And Clark testified at his deposition that Manning told him that the dog didn't act like he wanted to let her catch the old stray dog. So again, speaking to the knowledge requirement of this statute, this suggests we're not going to get it. Right? So maybe a little bit more detail and facts that Clark's not home at the time of the incident, not aware of any problem, not notified of any problem, and also this speaks to reasoning. So while Joyner is claiming that the Clarks were on notice, the court's finding that they actually were not. A little bit more detail here. Georgia has traditionally adhered to the first bite rule in deciding whether a dog owner has knowledge that his dog has the propensity to bite someone. Think for a moment, where does that go? Probably in your rules section, right? It says rule in it, first bite rule. So thinking about that probably goes in your rules that Georgia adheres to a first bite rule when deciding the knowledge piece of the statute. There have, however, been some recent cases which look at whether the owner had prior knowledge of his dog's tendency to attack humans and superior knowledge of his dog's temperament. Again, refining that rule. We usually adhere to the first bite rule. However, there are exceptions in recent cases. So looking out for terms like generally, traditionally, as well as however, but that usually signals a general broad rule as well as some sub-exceptions, such as in this case. So here, Joyner has introduced no evidence that this dog had ever bitten anyone before, and also has introduced no evidence that the dog had a tendency to attack humans or that the Clarks had any knowledge about the dog's temperament that would have put them on notice that the dog would bite someone. The evidence in the record, as described above, shows nothing that would put the Clarks on notice of their dog's vicious propensity. Therefore, the trial court erred in denying the Clarks' motion for summary judgment on Joyner's claim. What is this? A lot of reasoning and also our holding. So remember, the holding is the answer to the issue presented, which you may be thinking to yourself now that I mention it, we didn't see any line that told us what the issue presented was. You had to sort of infer it in this case. Sometimes the court will say, the issue here is blah, blah, blah. But in this case, we don't have that. Instead, we have to sort of put the issue statement together based on our reading. So what does it all look like put together? Here's the first part of the brief. So heading, remember a caption or a heading just to tell you what case it is. Who are the parties? So the plaintiff is John Joyner. The defendant is Thomas and Beverly Clark, who are the dog owners. I also have this phrase respondent and petitioner. So that's referring to the appellate level. So Thomas and Beverly Clark were the ones petitioning for appellate review. So they were the ones bringing the appeal, whereas John Joyner then is the one responding to the appeal. So those are other terms you may hear having to do with who the parties are and how they're related to the case at hand. Then really short procedural history. Joyner sued the Clarks for a dog bite. Clarks filed a motion for summary judgment. Motion denied. Now on interlocutory review to appellate court. Pretty brief, not a very detailed procedural history here. Not all cases have a very detailed procedural history. Sometimes it'll just be like, Clarks lost and appealed. It could be something really short. A little bit more in the facts here. So from that first page where we got that nice big paragraph of facts, we learned that Joyner went to the Clarks' house. The two dogs ran at Joyner. When Joyner put his hand out to stop them, one dog bit Joyner's hand inside. So distilled that paragraph in just 3 bullet points. And then also we had this additional information we got from later in the case about the allegations that the dog previously acted aggressively towards an animal control officer, but no growling, barking, and Clark's not aware. So those are all of our really relevant facts here. I didn't include the dog's name. It didn't feel important enough to make it into my brief. But you could see how I've distilled 2 chunks of information into a few bullet points. It's important to summarize the facts for yourself in this way rather than copying and pasting, because then you're developing a deeper understanding. The same is true with any of these sections. You want to put it in your own words as much as possible. Then issue question presented. This is what I kind of inferred from the situation. So whether the trial court properly denied the Clark's motion for summary judgment is kind of my broadest issue. That's really why we're in front of the court. But then as I was reading, it turns out that we were really focusing on the knowledge piece. So I added a kind of refined issue statement, whether the Clarks knew their dog was vicious or dangerous. So broad issue statement of what the court's doing. But then as I was reading, I was like, you know what? The court's really honing in here on the knowledge piece. So my issue statement should address that. Then remember, the issue presented is the question. So then the holding is the answer. So whether the Clarks knew their dog was vicious or dangerous, no. Whether the trial court properly denied the Clarks motion for summary judgment, no. And the reasoning here is the same, because there was no evidence that the dog had bitten anyone before and no evidence that the Clarks had any knowledge that would put them on notice that the dog would bite someone. The trial court erred in denying the Clarks motion for summary judgment. Very similar to the court's language here, because I couldn't think of a better way to put it, but you could break it out into bullet points if that's more helpful to reference during class. So then continuing in, I lost my chart lines, continuing into the rules. So I distilled the statute into just a 1 sentence here, and I added the statute number just for reference. A person may be liable for an injury caused by their vicious or dangerous animal. That statute gave us a ton of text, but not all of it was super pertinent to the case at hand. So I kind of distilled it down for just ease of reference in my notes. However, the next part that the court added using prior case law, that precedent piece, was really key. Must show that 1, the dog was vicious or dangerous, and 2, that the owners knew it. So really breaking down that there are 2 pieces here that the court would have to address in a dog bite case. And then distilling down that information about first bite rule. Georgia adheres to the first bite rule. However, an owner may have prior knowledge. So these are all the rules we drew from the case. And I will say the rules are kind of the takeaway of every class and every case, because you're never going to get the Clark and Joyner situation again. It's never going to be exactly the same as Bud, the mixed breed 12-year-old male. But this rule, you're going to be able to, and we'll talk in just a few moments about how you're going to do this, but this rule is something that you will apply to the next case when it's Mac, the 1-year-old pit bull. And so, you're really thinking through what can I take away from these cases, and the rules and reasoning tend to be the most impactful pieces. So those are ones that if you need a few more words to get down the exact essence of a rule, take that space in your case brief because that's the important piece. And reasoning, I kind of distilled it down to no evidence in the record that the dog bit anyone before or tended to attack humans, and no evidence that the owners were on notice. And so the disposition was reversed. I also generally like to have a section that's just my own ideas. So what did I think about this case? So maybe I have particular thoughts about the first bite rule that I want to jot down. I left it blank here because for the purposes of this video, but it's nice to have a section of your case brief where you can give your own like little summary or your own ideas of what you think about the case. So that's case reading and briefing in a nutshell. To be quite honest, you don't really start to get it down until you just do it a lot of times. So like I said, those first couple cases are going to be tough, but you can absolutely do it. Just think through at the end of each sentence, what information does this get me? And stick it into your brief or make a note and then come back and brief later. I know a lot of students like to read through it once just to sort of get the general structure and an understanding of what's happening in the case, and then read a second time to do the case briefing. It's up to you on that point. I think there's benefits to different ways of reading, but really those first few cases especially, really stop after each sentence or each paragraph and think, what information did this give me for my case brief? And you'll only continue to get faster at that thought process. So next up is rule synthesis. So synthesizing is combining a number of things into a coherent whole. And this is what you're really doing in practice as well as in class. And so rule synthesis speaks to two pieces of the lawyering process. First, understanding the governing rule, and then understanding what parts of the rule you must explain. So what does this mean in practice? So as an example, would one case on abuse of a dog who is left outside in the cold give you all of the information you would ever need about what constitutes animal cruelty under the law? Probably not. There's so many different situations that are different from a dog being left outside in the cold that could constitute animal cruelty. And so you can't really just pick out one case and hope it applies. You also can't just read the most recent case. You might be thinking to yourself, well, shouldn't every case summarize the law up to that point such that I can just pick the most recent case and give that a read? No, that's not really how the judges write. One case won't have all the information you need in it, which is why we need to understand how to create a synthesized rule by combining all the relevant law from your legal research, which you'll take legal research and writing to get a better sense of that. But when we synthesize a rule, we're really taking all the relevant law and plopping it into one succinct paragraph or a couple succinct paragraphs, depending on the complexity. And each case that you read adds a new part or parts to that rule. And then you piece the rules together to create your synthesized rule. And then that can be used to answer new questions about that specific area of law. So what will your final rule statement look like? It'll be easily understood. So as simple and concise as you can get it. It'll be unambiguous, where each term is well defined, and also you're not falling into a circular meaning. You're trying to get something that could be readily applied and you're not just talking in circles. It should also be consistent. And so if you apply your rule to existing cases, the rule would accurately predict the outcome such that you are confident that you can consistently predict a future outcome when your client comes to you with a problem. And so taking a step back for a moment, where does most law originate? Statutes. I mentioned it during the Clark v. Joyner case, but statutes are generally what comes first. So the legislature makes the laws, and then case law is usually where the judiciary is interpreting the statute itself. So it generally comes second. So that's our usual process. And so when you think about synthesizing a rule, you're always going to kind of start with a statute, if there is one, and then look to the case law interpreting the statute. So let's do a quick exercise about no vehicles in the park. So the state of Utica has a lovely park in its center. The legislature wishes to preserve the feeling of nature undisturbed by city noise, traffic, pollution, and crowding. It's a place where people can go to find trees, flowers, grass, and quiet. In addition, there are playgrounds and picnic areas. In order to make sure the park stays as it is, the legislature has passed a law that states there shall be no vehicles in the park. And at all entrances to the park, a no vehicles in the park sign is posted. So starting off with our statute, it's literally just no vehicles in the park. How can that be ambiguous? Believe it or not, it can be. Even a statute with only those 5 words, no vehicles in the park, can cause all kinds of problems in court. So let's start. So we know no vehicles in the park. You might have a kind of idea of what they're trying to prevent, but let's look at some case law to see at how this statute has been interpreted. So let's look first at Beautifica v. Smith. So John Smith lives on one side of town and works on the other. And to avoid being late for an important meeting one day, he drove his Honda Accord through the park on a paved street. A police officer stops him and he is charged with violating the law. You could probably predict what the court ruled in this one, right? Yes, this conduct is prohibited. A car is plainly a vehicle because its purpose is to transport passengers. And the statute's purpose, in part, we know from what we were told the purpose is to protect the public enjoyment of the park against traffic, noise, and pollution. And a car thus fits within the spirit of the statute. So we know from the Smith case, a car is a vehicle prohibited in the park. But then we find this other case, Beautifica v. Stodd. So Stevie Stodd, a 3-year-old, drives a non-motorized toy car that his father gave him into the park. A police officer stops young Stevie. He's charged with violating the law. Besides being a little ridiculous, you can also probably predict the outcome of this case. No, this conduct is not prohibited by the statute. The toy car is not a vehicle for purposes of the statute because its primary purpose is not really to transport passengers, since the child is just using his feet for propulsion and the toy car is not doing the transporting. So now we have Smith and Stodd. So what do we have so far in terms of rules? So first, we have that a vehicle must have a primary purpose to transport passengers. That came from both Smith and Stodd. We also know from Stodd that a vehicle requires more than simple foot propulsion. And we know from Smith that a vehicle has to contribute to noise or air pollution or contribute to traffic congestion. So our rule is coming together, but we find one more case. Beautifica v. Bode. Julie Bode rides her bicycle through the park on her way to a friend's house. A police officer stops Bode and she is charged with violating the law. So now we're faced with the question like, okay, what do we think about whether or not the court will think that a bicycle, is that a vehicle? Is that not a vehicle? Let's look at what that court found. So yes, the conduct is prohibited. Okay, they decided that the bicycle is in fact a vehicle under the law because its primary purpose is to transport passengers. And the bicycle uses more than simple foot propulsion because those foot pedals are connected to the wheels and the gears, and without these, there'd be no forward motions. And also, the court considered that bicycles make for traffic within the park. So now we know that a bike is also a vehicle within the meaning of the no vehicles in the park statute. So looking at where we're at now for rules, adding in Bode, so we still have from Smith and Stodd that a vehicle must have a primary purpose to transport passengers. A vehicle requires more than simple foot propulsion. Foot propulsion that's connected to additional mechanisms required for movement indicates a vehicle, and a vehicle must contribute to noise or air pollution or contribute to traffic congestion. So that's our we're putting together the rule, we're synthesizing it now. We kind of feel good that we have our pieces. So now that we've dealt with Smith, Stodd, and Bode, let's put our attorney hats on and talk to our new client. So a client just made an appointment to meet with you about a legal problem. Mr. Ed has been charged with violating the no vehicles in the park law for driving a horse-drawn carriage in the park. Okay, so already you're thinking horse-drawn carriage. How does that fit in with what we know? Mr. Ed wants to know whether it's worth challenging the case against him. So you'll need to research the relevant cases, and luckily we just did that. We were a little psychic there, and then create a synthesized rule that will guide our analysis. In this way, we could then predict whether Mr. Ed will be successful in a legal challenge. So let's figure this out. We'll start by synthesizing the rule together. A good rule of thumb for rule synthesis is asking what, as in what is the overall legal standard. This is usually what comes from the statute, the very broad legal standard. Then how? So how is the legal standard met, or how have courts applied it? This is the piece which comes from the case law. And then your third question is, are there exceptions? This would also come from case law. So based on our rule, we can give Mr. Ed advice, or we could give, our boss advice about whether or not to take the case, or we could answer an exam question. This is exactly what you're doing in your classes throughout the semester so that during the exam, you could face a new legal problem like Mr. Ed's and predict an answer. And there's a formula for telling someone our answer to Mr. Ed's legal question, and it's called IRAC. And so you may also hear CREAC, CRAC. They're all some iteration of IRAC. We still think of IRAC as kind of the gold standard in legal analysis and writing. There's some different slight iterations of it depending on the context, but we'll focus in on IRAC. So issue, rule, analysis, conclusion. Walking through each of these with our problem, the issue statement will really be what does Mr. Ed want to know? And what do we need to know to answer his question? And so we might articulate this issue statement here as the issue presented is whether a horse-drawn carriage is a vehicle for the purposes of the No Vehicles in the Park law. So really honing in here, right? It's not just will Mr. Ed succeed? It's what's the key sticking point here. It's whether the horse-drawn carriage is a vehicle. Then we'll synthesize our rule. And so I'll show you my synthesized rule, but if you want to pause here and try synthesizing your own based on what we know, feel free to do that. But my rule starts with the what. The state of Beautifica protects its green space by mandating that there be no vehicles in the park. This is the statute. So it's highlighted in blue just to show you that this is the what part of our rule statement. And then the red is all the how. And there were no exceptions in this case, so there is no green, but the green would also be in there. The courts have defined a vehicle as an object with a primary purpose to transport passengers. To constitute a vehicle under the law, an object requires more than simple foot propulsion alone for movement. However, when foot propulsion is connected to additional mechanisms on an object which are necessary for its movement, that object constitutes a vehicle under the law. Moreover, in order to constitute a vehicle under the statute, an object must contribute to noise or air pollution or contribute to traffic congestion. And I left this is not proper citation format to just put the case names in parentheses. You'll learn proper citation format in legal research and writing. This is just for ease of reference, and so it doesn't get too weighed down. Also, on exams, your professors may not even expect you to cite to specific cases. They just want you to know the rule. You'll have to defer to your professor on that one. But this is the full synthesized rule. Put it all together. So we took pieces from 4 sources, so the statute, Smith, Stodd, and Bode, and put them together to put together a rule statement that now we can use to analyze Mr. Ed's problem. Which leads us nicely into our A of IRAC analysis or application. And so you might have noticed that up until now, we really haven't talked about our client at all. We mentioned there's a horse-drawn carriage in the issue statement, but we didn't really give much weight to that. And this is as it should be. We spend the first part really focusing in on what the rule of law is. And then the A in IRAC is when we finally take our client's specific facts and apply them to the law that we have ascertained. And so this is where your independent analysis becomes important. So if you want to, take a moment to pause, think through how you would analyze this problem based on the rule that we know. Here's my analysis. So here, usually we start an application analysis with here, just to signal that we are moving to our case. Here, Mr. Ed was driving a horse-drawn carriage through the park when he was stopped for violating the law. Mr. Ed's horse-drawn carriage is probably a vehicle for purposes of the law because it has a primary purpose of transporting passengers. This is evidenced by Mr. Ed riding in the front seat of the carriage as it moved through the park. So you can see, I've just taking a pause right there. You can see I've matched the law that primary purposes of transporting passengers to the carriage with also this backup information of how we know that the primary purpose is transporting passengers. I don't just say the horse-drawn carriage is for transporting passengers, period, moving on. I give a little bit of weight to that and why I believe that. So while the carriage does use foot propulsion for forward motion, specifically horsefoot propulsion or hoof propulsion, that propulsion is connected to additional mechanisms required for forward motion. So in this case, those mechanisms are the reins, harness, and hitches that attach the horse to the carriage and are needed components for the forward motion of the carriage. So really showing my reader, whether that's Mr. Ed, my boss, my professor, I'm really showing my thought process here. And then moreover, the horse-drawn carriage contributes to both noise and air pollution, etc., whatever you want to say there about horses and horse-drawn carriages. So really walking through each portion of the rule, I just, in the interest of space on this slide, I didn't continue on with the noise and air pollution. But you could see how your analysis application matches the rule to the facts and each component of that rule to a piece of facts that helps show how you will reach your ultimate conclusion. In my case, that the horse-drawn carriage is probably a vehicle for purposes of the law, and Mr. Ed is unlikely to be able to mount a successful legal challenge to the charges against him. So just to show you what this all looks like together, I just read it to you. So it's the same thing, just put on one slide, all smushed together, except I wasn't able to get the conclusion on there, but just tack the conclusion on at the end. Feel free to read it all together so you could see the matchiness of the law and the facts. But that's basically what you're doing when you're reading cases, looking at new client problems, looking at your exams. This is the process you're doing. I do want to make a quick note on finding relevant cases. So what if we had found one more case that dealt with an airplane, which the pilot flew really low over the park? It creates a lot of noise and pollution, but in that case, the court spent a lot of time determining whether the airplane was in the park for purposes of the law. For Mr. Ed, would we want to look at that case? Would this factor into our analysis? Probably not. There's probably no dispute here. And from what we know, there is no dispute here about whether Mr. Ed and his carriage were in the park. So probably not the most on point case. So when you're doing, research or when you're thinking through legal problems, you really want to hone in on what the precise legal issue is. What is the precise question you're being asked to address? So you're going to need additional practice on pulling rules from cases. This video is not going to be the do-all end-all of knowing how to pull rules and synthesize them. Cases won't all be straightforward. Our examples above, I didn't even make you read the cases. I just told you, because they're made up, I just told you what they're about. But they're not all going to be straightforward. There'll be lots of what seems like gibberish and lots of things that seem important, but maybe aren't. So it can be quite confusing. So again, make sure that you're being kind to yourself, especially in these first few weeks. Well, figuring out rules is a very difficult process, and it is a vital skill for success in law school and in lawyering, but ultimately practice makes perfect. And over time, it'll click and the relevant words will seem to jump off the page at you. So, don't be discouraged if it takes you extra time to read at the beginning, because eventually you'll get faster. But I will say, just in full honesty, there are still some cases that take me a few reads to really get the gist from them. And I've been doing this for years. And so, even once it clicks, you still might hit cases that are a little bit tough to figure out what exactly is going on and what you're supposed to be drawing from them. So don't get discouraged. You can absolutely do this. And, just at the beginning, just do your best, right? Do your best you can with the briefs at the beginning. If you want guidance, you're welcome to come by and talk to the Academic Success Program mentors who are 2L and 3L students, so upper level students who are very happy to share their tips and tricks. And I think you should do that if you're like, I'm really nervous about this, I need to talk to a student about it. By all means, please make an appointment with them through the ASP portal. But ultimately, you're going to develop your skills over the course of the first semester and throughout law school. And practice is what makes you better. So don't be discouraged. You can absolutely do it. Hopefully, you have at least a little bit of a sense of what you're doing with case briefing. You'll get practice right away for your first couple of classes, so don't worry, you'll get plenty of practice. And just do the best you can, especially at the start. Your professors don't expect perfection in the first day of class. It's all a learning process. But of course, if you have any questions, I'll see you at your orientation, but also don't hesitate to reach out to me or to our ASP mentors or to Katrina. Really, anyone in ASP can help you out and talk through this process.